name is Alphonse, Senior Appeals Counsel in the Office of the Prosecutor in Arusha. ICTR is an ad hoc tribunal with a mandate to adjudicate violations of international humanitarian law committed in a non-international armed conflict. The ICTR statute empowered the prosecutor to prosecute 3 categories of offenses: genocide, crimes against humanity, and violations of Article 3 common to the Geneva Convention and of Additional Protocol 2. However, according to the statute, the prosecutor may prosecute rape only as crime against humanity and war crimes. There is no provision in the ICTR statute to prosecute rape as genocide. And yet, rape and other sexual violence have been punished by the ICTR chambers as act of genocide. The Akayesu case is the very first case in the international criminal law history where an accused was convicted of not only genocide, but rape and other violence of sexual nature as an instrument of that genocide. It was also the first conviction ever for rape as a crime against humanity. So, the Akayesu case I mentioned is a great step forward in the international humanitarian criminal law. The prosecution of sexual rape, of sexual violence, rape is a key component to stopping the global violence against women. But how did we get to prosecuting rape at the ICTR? Our first indictment in the Akayesu case, in the beginning, did not contain any charge of rape. During the trial, 2 witnesses by themselves testified about rape. The first testified that it was a woman. She testified that her 6-year-old daughter was raped by the militia men. The second witness testified that herself was raped by the same militiamen. So the prosecutor asked that more or further investigation be conducted, and the trial was suspended. More of the investigation was conducted, more evidence was found, and more witnesses came to court to testify. And what we heard from those witnesses was horrible. The accused, who was the mayor of the communion of Tab, did things that no one could understand against women. They testify that the accused asked, ordered the militiamen to rape the Tutsi women to know what was their taste. And of course, many Tutsi women were raped in the Taba commune. The same accused ordered the Tutsi women, girls, to march, to perform gymnastics naked before a crowd of Hutu who was laughing at them. So from there, we realized that it was now very important to conduct a further investigation in the rest of the cases. So the prosecutor now investigated in all cases the crime of rape, and we found that the crime of rape was perpetrated in Rwanda in a very large level. About 500 women were raped, but that figure is an estimate. More, in reality, were raped. So, when we were investigating, we faced challenges. You know, it's good to be the first, but it's also demanding. It's challenging to be the first. There was no precedent in the international criminal law's history of investigation of rape. There was no example. So we had to set up, to establish a strategy of investigation. We are no longer investigating because since 2004, the Security Council asked to stop investigation and finish the pending cases. So no more investigation. We have 13 fugitives, 13 suspects who are still at large. We are still looking for them because some of them were very prominent figures in the Rwanda government or society. But we think that the tribunals in the future, starting by ITC, will focus on investigating and prosecuting sexual violence because it's a great offense against the women. I would like to salute the memory of Alphonse, who was the main prosecution expert witness in Arusha. Maybe we will see more this afternoon or when you ask questions, but there are so many things to know, to learn about the ICTR. Thank you.